How you guys doing this evening? Legal advice of the day. I'm here to talk about the 1976 Supreme Court decision that gave prosecutors absolute immunity, and so can I be sued for misconduct related to their advocacy in the courtroom. And a very famous case that brought that into play is the Imbler versus Pachtman 424 U.S. 409 that happened in 1976. So let me give you a brief about this. So basically, what we have in the United States now after 1976 is prosecutors, district attorneys, or whatever you want to call them, now have absolute immunity for their misconduct in the courtroom. And, now we have it to where prosecutors can now pretty much not get sued or not be held liable for their dirty work that they do in both state and federal courtrooms. The Supreme Court ruled on that, and pretty much prior to the Supreme Court ruling on that, we had a lot of prosecutors getting away with this thing called prosecutorial misconduct. Prosecutorial misconduct is basically falsifying evidence, coercing witnesses, soliciting and knowingly sponsoring perjured testimony, withholding expository evidence and or evidence of the innocence, introducing evidence known to be illegally seized at trial, initiating a prosecution in bad faith, in other words, for personal reasons or with knowledge that the individuals didn't commit the crime. And that's very, very dangerous that we're giving prosecutors pretty much complete immunity to not be held responsible for their dirty work. And as you can see, these same prosecutors that we have in today's offices, I'm not saying all, are pretty much, they know that they have immunity, just like officers, they have immunity. They know that they have this immunity, so they're taking advantage of it. And what I'm going to do is, because I did a lot of research on this, I'm going to break down some of the cases that prosecutors have really practiced prosecutorial misconduct and actually got away with it, knowing that it's a bad thing. So let's go over what is prosecutorial misconduct in the layman's terms. So let's go with falsifying evidence. So now, since the Supreme Court made the decision to give complete immunity to DAs and prosecutors, they can now falsify evidence and pretty much get away with it. So your son, your daughter, your cousin, your brother, your innocent family member can now pretty much go into a courtroom and be convicted of a crime, even though that prosecutor plainly did this, falsifying evidence that he obtained from the police department, and he know that he can get away with it because of the immunity. Now, I'm not saying that these prosecutors is out here saying, you know what, I'm going to falsify some evidence, I'm going to lock these people up, I don't care what happens. It's not that. It's more of when they get these police reports and these and this information from the local law enforcement, and it's not completely a thorough investigation, because we do have a lot of police officers that is out here not doing thorough investigations. What's going to end up happening is that prosecutor can take that that half dead evidence and pretty much present it to the courts, and you or your family member can pretty much be thrown in prison or jail because this prosecutor has pretty much absolute immunity to pretty much falsify evidence. Now let's go to the second thing: coercing witnesses. Coercing witnesses is basically saying that, hey, you know what, I know you've seen the crime, but I need you to go more in detail. I know you've seen the crime, and I know you didn't see much, but I need you to say this, or I need you to do this, or they can say, you know what, I give you a stipend, or I know you didn't see this particular person doing this crime, but I need you to say that you seen this person do the crime because I want to really lock this person up. Now, I'm going to say now, but ever since 1976, when the Supreme Court gave the prosecutors and district attorneys absolute immunity, coercing witnesses is pretty much legal. Now, it sounds bad, and I'm not saying that all prosecutors are doing this, but pretty much coercing witnesses is pretty much a thing that prosecutors and district attorneys can pretty much get away with it and have absolute immunity and not be punished for doing that. Now let's go to the third thing of prosecutorial misconduct: soliciting and knowingly sponsoring perjured testimony. Pretty much what that means is, let's say a witness is, seen a crime or seen something take place, or let's say, um, just not just a witness, just anybody on the streets, and they pretty much gave multiple statements to law enforcement. It could have been anything, like they couldn't see correctly, or I heard something differently, or I smelled something differently. Pretty much, prosecutors can now pretty much solicit and knowingly sponsor perjured testimony. They can pretty much manipulate the testimony and pretty much get away with it, which is a form of prosecutorial misconduct, which now, since the Supreme Court gave them absolute immunity, can pretty much, they can't be sued or held liable for doing this. Then let's go to the fourth thing. Withholding is supposed exculpatory evidence and or evidence of innocence. So pretty much with that, let's break that down. So when you're a defense attorney, which is something I'm trying to do, I have a right to file a motion to suppress evidence. As a defense attorney, I do have the right to see the evidence of the accused so I can prepare my defense. Now, under prosecutorial misconduct, let's say if I'm going against a district attorney, and let's say there is some evidence out there that really proved that my client is innocent, this prosecutor can pretty much withhold that evidence and say, hey, I'm not giving you anything, and it doesn't matter what motion you file. I don't have to. I can withhold this evidence because I'm protected under absolute immunity. And yeah, I'm practicing prosecutorial misconduct. He's not going to say that, he or she's not going to say that out of his mouth, but he's protected under absolute immunity. And he can pretty much withhold exculpatory evidence and or evidence of innocence. He can have something in his back pocket that shows that my client is innocent, but just because he want to see my client go to jail, he can withhold that, and he won't. I can't sue him. My client can't sue him because he's protected under absolute immunity, and he's absolutely practicing prosecutorial misconduct. Because again, the Supreme Court in 1976 gave district attorneys and prosecutors absolute immunity under the case of Imbler versus Pachtman for 24 U.S. 409 in 1976. And let's go to the next thing of prosecutorial misconduct: introducing evidence known to be illegally seized at trial. So basically what that means is when there's a crime that takes place, and let's say the police department investigate the crime, and they do a thorough investigation, and let's say that the police department did some shaky things or took some evidence, or illegally obtained a warrant, or they did probably get a warrant but they wasn't supposed to search a certain thing, or they didn't get a warrant, or they didn't read somebody's rights, or anything like that. What with prosecutorial misconduct, when it comes to introducing evidence known to be illegally seized at trial, is, let's say if a police officer goes search someone's home without a warrant, and it wasn't for an emergency, he just searched someone's home, and let's say he found a gun, and he's supposed to get a warrant to search this person's home because it wasn't probable cause. Probable cause is over 51 certainty, and a hunch is 0% certainty, and mere suspicion is less than 20% certainty. Meaning that in order for you to just run up in somebody's house, you got to, of course, have a warrant. But let's say if someone's on a run and they run in the house, it's called emergency circumstances. That's the legal term. But let's say none of that took place. Let's say this officer just went and just searched this person's house because he have a hunch. A hunch is zero certainty, meaning that it's nowhere near probable cause. He can't search that house because it wasn't emergency circumstances. So me, as me trying to be a lawyer in the future, let's say if I question that officer, say, hey, did you have a warrant to go search this person's house? And he say no, but he went and searched his house anyway because you protected by the Fourth Amendment. And let's say that the prosecutor still trying to throw my client in jail from having this gun. Well, under prosecutorial misconduct, this officer just introduced evidence known to be illegally seized at trial. That gun was illegally seized. It wasn't an emergency circumstance. It wasn't like he was on a run and he ran into the house, because you can certainly get searched for that. It wasn't a 51% certainty because of probable cause. It was pretty much off a hunch, or it can be an unreliable informant, or it can be mere suspicion. So if this gun was illegally seized, why is this prosecutor still trying to throw this person in jail knowing that he didn't have a warrant? Well, under prosecutorial misconduct, he introduced this evidence known to be illegally seized at trial. That officer did not have a warrant to go search that person's house, and he, yes, he found the gun, but the way he went by it is he violated my client's Fourth Amendment right. Why is this prosecutor still trying to charge my client with this gun? Well, under the prosecutorial misconduct, he pretty much introduced the evidence to be illegally seized. And the reason why he's doing that to people, and this is very common, is because he has absolute immunity that was given to him after 1976 by the Supreme Court. So they're pretty much getting away with, what I mean, introducing illegally seized evidence right in your faces. You just don't know nothing about it. Now, I really, when you guys see this video, this is just part one of it. I really want you guys to really look up. I really want you guys to look up the 1976 Supreme Court decision that gave prosecutors and district attorneys absolute immunity. And I really want you guys to look up some cases. I'm going to break down some cases in part 2 and part 3. But let's just continue going on with this prosecutorial misconduct and see what they really getting away with. The next thing that is under the umbrella of prosecutorial misconduct is initiating a prosecution in bad faith. In other words, for personal reasons or with knowledge that the individual didn't commit the crime. So let's break that down. So with personal reasons, it can be politically motivated. I read a case actually right here that talked about political motives. And a case that I came across was Bernard versus County of Suffolk, 356 F.3D 495 Second Circuit in 2004. And pretty much this is a white male. And I'm gonna read the case brief to you. It says, in this case, prosecutors were found to be entitled to absolute immunity for the decision to prosecute town officials regarding of whether the prosecution was initiated solely because of illegitimate political motivations, which means personal reasons. The court held that certainty, racially envious, or partisan prosecutors pursued without probable cause are reprehensible, but such motives do not necessarily remove conduct from the protection of absolute immunity. Regardless of the defendant's political motives, absolute immunity shields them from suit pursuant to 1983, ID at 504. So basically, that case brief that I just read was an individual that was victimized by prosecutorial misconduct for personal reasons or with knowledge of the individual didn't commit the crime. That individual that I just read, he did not commit the crime. And he still went ahead and tried to prosecute that person for that particular crime. These prosecutors know if a person really committed the crime or not. They have access to case law, just like me as a future attorney have access to LexisNexis and doing investigations and people that's in their office that actually investigate these crimes as well. So that's just part one of the 1976 Supreme Court decision that prosecutors have absolute immunity to not be sued or held liable for their prosecutorial misconduct.